respectfully submit yes, my lord.
Or an agreement between the parties about what orders should ensue.
Yes.
Has a time frame been fixed, Mr. Arkansas, with regards to when the disciplinary proceedings will commence and the like?
But of course, you haven't mentioned that the respondent agrees to.
Well, I had raised it with Mr. Katz, and he had indicated that his client was not agreeable to that proposal.
Yes.
Okay.
All right.
Thank you. Thank you.
Thank you very much. Let's see again. Did you get it? Try and get attitude. Mr. Marcus, I wonder if we shouldn't.
Would you prefer me to wait?
Hear Mr. Katz just on this aspect that we've
Certainly.
been discussing now with.
Certainly.
Yes, thank you.
Yes. Thank you to the court. Our argument overall, the DA's argument overall, is that the court's debate with our learned friends concerning the interrelationship between Part A and Part B, with respect, is misplaced. Let me say why. That will be the first chapter of what I'd like to say. The second chapter of what I'd like to say is this. What the High Court did was apply an exercise of jurisdiction under 172(1)B, because it was a constitutional matter within its power. And when it did so, it considered the facts, and those facts point to the orders that he made in toto. Every one of the orders that he made are justified by the facts as being just and equitable orders concerning this case. And we will submit there can be absolutely no criticism of Skipper's J's orders when the court has regard to the facts. The facts are outrageous. And the fact that I'm here standing today listening to the public broadcaster and the minister defending what happened is not acceptable under any constitutional dispensation.
Well, I don't know how you can say that, Mr. Katz. They have a right. This is a court, and point scoring is not what this is all about. Let me say this. I find that objectionable. What you've just put to us now, I find objectionable. I find it objectionable on this basis. It doesn't matter how bad you think their case are. They have an entitlement to have to argue the matter. So please, I'd ask you to retract.
Justice Nafsa, I retract it to this extent, if I may. The appellant parties accept now that there ought to be a disciplinary hearing. They do not accept, as I understand what has been put, that there should be a suspension. Now, the question arises, I can understand fully why the third respondent would take that view. The court put it to our learned friends this morning, and we accept that absolutely acceptable.
Let me put something else to you. It is now a year since all of this started. He's been in that office up until now. It's not a fact we can wish away. It's a month to go before your review proceed. Now, what do you want us to do? Suspend him for the month? Besides all the other difficulties. And what I'm saying to you is perhaps the indignation should be tempered. It's much like, we adopt positions that become entrenched. But I just want to put this to you. The whole attitude has been, right from the beginning, and let's say that you're justified in being disappointed that the concession comes so late. Let's just leave it at that. I'm paring it down as best I can. I'm trying to find neutral language. So let's say you're disappointed at that. If you look at the public protectors, and that's why I think we should temper all of this with all of our expectations. If you look at what the public protector says in a report, but what remedial steps should be taken by Minister Curry. remedial steps she suggests should be taken, where she says should be taken in respect of what the minister should do, are now the steps conceded. Now, what that means in simple terms is that everybody here gets their day. She's vindicated. Mr. Motsweneng gets his day. And you know, we can debate at length what Justice Skippers did. So in a sense, I considered it to be a win-win for everybody. But quite clearly, there are different parameters from where you come. The instructions will be different. But I just don't understand what the difficulty is if the public protector's core finding, a core remedial action is now being exceeded.
Justice Nafster, we would regard discipline without a suspension as a loss for the reasons set out by Skippers J in paragraphs 98 and following. And Justice Swain explained what Skippers J had found in this respect in 95 and 96, volume 5, 812. It's a loss on the facts. On the facts, and I'll repeat the words. Justice Skippers said, on these facts, the allegations of misconduct against him are serious. He's the CEO, executive member. He has virtually unlimited authority. It was read to Mr. Manechi this morning. Now, were there to be discipline, and one has regard to that which Skippers commented about suspension pending discipline, we say cannot be faulted in any way.
I don't understand that. You see, I mean, this sort of, perhaps that's the difficulty in this country, a sense of loss and winning, and rather than the institutions. I just find it all gets lost in the wash. Let's just start again. The reason the public protector wanted disciplinary action to be taken is because it would then deal with the whole question of his suitability for office and everything else and all of his actions. When you get that conceded now, and you can go back to 95, the fact of the matter is he's been in that position until now. The public protector has said, let's get a disciplinary inquiry. When you get two instruments of state, plus the person at the center of all of this, wanting to accept the integrity of the public protector's office, then what is it from the DA other than political point score?
No. With respect, Justice Nafster, we are here to defend a judgment in our favor. And I want to refer to the Constitutional Court judgment of Trencon. I've got copies, but the principle there was that the High Court set aside a tender and substituted its own decision. The Supreme Court, this court, set aside the substitution order on the basis that the High Court had misdirected its just and equitable jurisdiction under Paja, the section. The Constitutional Court turned round and said it wasn't for the Supreme Court of Appeal to do so because when the High Court in that case, Carstensen AJ, had granted substitution relief, he granted that relief as part of his true discretion rather than loose discretion. In those circumstances, it wasn't for this court to interfere with the question of the true discretion being exercised unless it could be shown that the High Court had misdirected itself and chosen an option which wasn't one of the range of just and equitable options. And we submit that when one has regard to that which Skippers found, those are the 5 orders that are set out in 8348.
Let's look at the practicality. How would you
reality.
The first prize for your client is a disciplinary proceeding? That's what you want. Well, that's what you need to court about.
Justice Swain, prayer 2 is suspension.
Well,
And that's first prize.
Yes. But you know, sorry, even if you are technically right, pragmatic, what is the objection?
Well, if one has regard, this is my first chapter. When I started my introduction, that was my first chapter, and that's the concern that I have with the debate that the court had with our learned friends this morning.
Well, without agreement from the appellants, are you going to get disciplinary proceedings before the review takes place?
Maybe, and the question is it's irrelevant. Because in the Part B, there is no discipline. Part B has got nothing to do with discipline. Part B is the fact, sorry, with respect, if I might just finish this. If one has regard to the prayers in Part B, on page 4, paragraph 7 to 12. They don't deal with the public protector other than Prayer 11, which is a declarator. There's no question of discipline in Part B. Discipline only is in Part A.
No, but you're running conceptual lines across each other. Because Part B, if you won on Part B, on one of the issues, the relief you got would be subsumed. So if you got a review on the basis that he shouldn't have been appointed in the first place, and with the greatest respect, no thought was given to this at the hearing in the court below, either by the parties or by the judge, because that's the difficulty. You went in there with a Part A, and I can understand it. The Part A is, you always understand, you go in with a Part A, it's a holding exercise, we'll do Part B, and the threshold is lower. Okay. But, except, just the skipper said, well, you're really dealing with final relief, but didn't actually consider that there's stuff in Part B that would cut across. And more than that, going back to judgments way back, decades ago, that you shouldn't encourage piecemeal litigation and protracted litigation, including appeals.
But, sorry, I was answering Justice Swain's question on the question of, were there to be a disciplinary inquiry, let's say without suspension, wouldn't that cut across Part B? Because Part B...
No. I said, if in fact the review, what I was saying is that if in fact the review is going to go ahead in 1 month's time, if the disciplinary proceedings can't be commenced and finalised by that time, the review will take precedence. If in fact in the review, Mr. Matsuane, it's found that he shouldn't have been appointed, then the disciplinary proceedings fall away.
Not necessarily, that's my point. That's the whole point. Sorry, Justice Swain, that's the whole point of how I started my address this afternoon. We submit that that debate misses the fundamental question what we asked for in our notice of motion. That's the point.
Well, then the point should have been the following. You should have asked for final relief in respect of ASAB.
Well, let's look at Justice Maps. I cannot get away from that which we've asked for. And what we've asked for in 2 is an interim order. In 3, I can't get away from the fact that 3 is framed in a way which is final in effect.
Well, therein lies the problem. Because it wasn't thought through, the proliferation, and this court has said repeatedly, what seems as a bright idea at one point to cut things up often comes back to bite you. And it is going to come back to bite you.
So, with respect, Justice Nafsa, with respect, Prayer 3 directs the board to institute disciplinary inquiry. Now, that applies whether he's the COO or the acting COO. So if, for example, Part B is successful on, let's say, for example, an RD ground or technical ground, and I pick up with Justin Ponnen this morning that there was no interview procedure, there was no... Let's assume that that's the case. Then, and we debated this in Similani with the Constitutional Court, the effect would be that he would be put back into the position of acting COO. And then the question arises...
If you're good on that, and for the moment, given your arguments in it, you would have every confidence you'd win on that, because your story is there was appointments, there were no advertisements, there was no competitive behavior, all of it. So that is a slam dunk from your perspective.
But not a slam dunk that he would then be not entitled as of right and of the law to continue to be the acting COO, and that's the problem.
So what is it that you would want to see now?
What Skippers J ordered. It's appropriate, it's just and equitable, and it fits the facts. And that's what we come here to say. And even though, and I have to accept, I don't run away from it, that's why we're here, that the order that is contained in Notice of Motion Part 8, Part 3, is final in effect. I accept that. I accept that Order 1 by Skippers was final. That's why we're here. That's why we didn't oppose in the way that we did the application for leave to appeal on that basis, and we did not. He's given a judgment on
Let's look at paragraph 3. Paragraph 3, of the Notice of Motion. Let's look at paragraph 3, because that's what you sought finally. And that's why this idea of cutting things up is a bad one. Let's look at it again. If in fact the disciplinary inquiry found that he was a person of zero integrity, and I would, from what you say in respect of all of your documentation and the full might of your founding affidavit, the answer would be that would end it. It would have nothing to do with him being able to be replaced or moved back into the prior situation. So if the disciplinary inquiry, if the disciplinary inquiry were to have started and commenced at the time that it was, as it was contemplated in the order, and it had finalized, and you had been vindicated on each one of your points, particularly your integrity point.
Yes.
So
This is in the disciplinary inquiry. In the disciplinary
yes,
inquiry.
the disciplinary inquiry. We're not on the review.
Yes.
That would have been the end of the matter.
Perhaps,
No,
Justice
but
Nelson.
why perhaps?
Because what we've seen is that the disciplinary inquiry may or may not have resulted in a firing or termination of employment. But the question isn't whether his employment was terminated in Part B. The question of whether his appointment and recommendation was lawful. The Similani problem, which is absolutely different.
No, Mr. Katz. On your own version, on what's there in black and white, you can't take away from it. You say, this is a bad man. You shouldn't let him run a spaza shop. He is just the worst you can ever imagine at that. That's your case. That's your case. Now, if you win on that basis, that's the end of him. If the disciplinary hearing were to consider that you were right on that would be the end of him. He couldn't hold any position.
Justice Nafsa, that's part of our case. And I have to say that's part of our case. And let me explain why.
I'm sorry, Mr. Katz.
It's part of our case because we say the following. Whether he was the best or the worst candidate for the COO position, his appointment was irrational on the basis of Similani. Period.
But that's in Part B.
That's right.
We've only got A before us.
Yes, that's right.
Now, if you go to the notice of motion, the principal relief that you sought in paragraph 3 was the institution of the disciplinary proceedings.
That's right.
Now, if they concede that they are willing to hold the disciplinary proceedings, well, it's no longer necessary for us to pronounce on that.
On that issue?
Yes.
On that issue? Yes, on that issue.
So all we are quarreling about right now would be the suspension pending.
Correct. Absolutely.
So we are really quarreling about what in effect would be an interim order as drafted in respect of
Absolutely.
In respect of the disciplinary
Absolutely.
proceedings.
Absolutely. That's all the quarrel.
But Mr. Kent, when I put the proposition to you about the interrelationship between the disciplinary proceedings and the review, you said, well, the review may find that he should have been appointed as permanently as a COO, but he could still be an acting COO. But your relief in regard to the review contemplates that once his appointment is set aside, it then directs the boards to recommend the appointment of a suitably qualified COO within 60 days. And then there's additional relief if they don't do that. So how do you say you'll carry on acting indefinitely?
Depends on the relief that we may or we may not get paragraph 9.
Yes or no, we can say may not.
No, but that's the principle, because it depends when the...
Can I finish?
Yes, sorry,
What I'm
sir.
saying is the relief that you seek in the review contemplates his replacement. So your fears, hypothetically, you may or may not, but the relief you seek, in fact, covers that eventuality, that you'll get somebody else appointed to the post. So your idea about Mr. Watson carrying on in an acting capacity isn't valid.
Justice Swain, my answer to that question is this. We ask for prayers 7 to 12. Included in that is a directive that a new CEO be appointed. I have to accept that. But it may well be that the Part B court grants the review, but not the directive. So it's notionally possible that the fear that we have could arise. That's all I'm suggesting. I'm not saying that we won't get it.
Well, then surely the disciplinary proceedings could be adjourned until after the finalization of the review.
Mr. Katz.
Why do you frown? I don't think.
No, I'm not. I'm questioning. I'm trying to. I'm not. So, I think Justice Party put it to me. Well, the narrow issue that we're debating now is we've succeeded effectively in obtaining the relief sought in prayer 3 by the agreement between the appellant parties.
Well, they're only willing to do so in an attempt to find a practical solution.
Yes.
And that's why, I really want to put something to you. And I'll put it to you again, earnestly. I want you to take instructions and with the leave of my brother presiding. Because this is just, in a sense, it's, well, let's see how far we can push it. I'm just saying that if you just go with what's been put to you, we can all leave here with a little bit of dignity. And forget the entrenched position that your party finds itself in. Public protector is vindicated. We go away, and the dirty washing will all be aired. And that's all I'm asking you to do. I'm not asking you to do anything more than that. I'm thinking that just, you know, it seems to me that you're pushing to see what you can get as a sort of extra.
Justice Napster, this morning you put it to Mr. Medici that sort of less is more, perhaps, in a different context. It was a context of a suspension pending Part B and leave aside the disciplinary inquiry. And I shook my head, we would submit, I shook my head, because we would submit that for the reasons set out by Skippers J in 95 and 96, and paragraphs around it, the context, to ever, leave aside the fact of this case, to ever have a disciplinary inquiry against, for example, the MD or the CEO of...
Can you just hang on? There's something that's going on somewhere. Is it outside or is it inside? Outside. Goodness. Can you
sorry, Mr. Snaps. Apologize.
Tone down a bit.
As a matter of principle, we would submit that those concerns that are set out in 95 and 96 are factually appropriately concerns, and as a matter of principle, where one has, let's call it the big honcho, the main honcho in an organization, to be subject to discipline, and I come back to the point that you put to me that was offensive in a sense. The SABC is run by 3 executive members. On the facts, we know that the chief operating officer is that person who would be subject to this discipline. And on paragraph 98 of the judgment, one sees the reasons advanced why he should not be suspended on the papers.
We weren't antagonistic towards you. What my brother Swain put 95 to your colleagues, your opponents, is putting it to them on the basis that that would be a foundation for a finding that they're now amenable to. That's what the basis is.
I accept that. So but on paragraph 98, what Skippers J does is he sets out the reasons why suspension would not be appropriate on the affidavits. And he sets out 5 reasons. And he deals with all 5 reasons on the following paragraphs. And he explains why all 5 reasons, with respect, are not sustainable not to grant a suspension. And I'm only arguing why there should be a suspension pending what is now seemingly, and agreed by the appellant parties, a disciplinary process. And we would submit that Skippers J cannot be faulted on those, and that analysis of the 5 reasons put up by the appellant parties. So the appellant parties say, the board is responsible for exercising, I've got cases on that, if the court wants, a suspension would breach the rules of natural justice in that Mr. Motsoeneng would not be given an opportunity to respond to the proposed suspension. Suspension carries negative personal harm, etc., the 4 or the 5. He deals with it. 99, 100, 101, and he goes all the way through to 106, etc., etc. And we would submit that that analysis and those considerations, we would submit for this court to overturn the order that he makes in paragraph...
No, so far no one was suggesting that the order be overturned. No one was suggesting it. I think we spoke about a postponement for purposes of the institution of the disciplinary proceedings.
Yes,
that's what we were talking about. The question, of course, is what happens to the suspension. And what has been put to you is, well, he's been in his job all along, from the date that you got the order up until now. Why should he now be suspended for whatever period before you start with the disciplinary proceedings?
Well, perhaps...
That was the question.
And my answer...
But if you are not prepared to accept that, then I'm afraid we might as well just carry on.
My answer is that contained in Skippers J's judgment. It's there. It deals
No, we know that.
Yes, so my answer is that the disciplinary process itself will be seriously compromised if there's no suspension, as found by Skippers on these facts. One can't get away from these facts. One can run, one can hide, but the facts are that here is what on the facts.
Can I ask you this?
So it's not about him doing harm to the institution because he's been there all the time. It's about the possibility that he may interfere with the disciplinary process. Is that the reason he must be suspended? I'm just trying to get a sense because, you see, I mean, it may have been possible for you as well, if you felt so strongly about this, to go to the High Court and in terms of what's it, Rule 4911 or something like that, to have got an order for the suspension order to have been, to have been implemented.
Sorry, with respect, we did.
And then?
We did, and we got it.
And then?
Let's turn to that.
The
judgment is on page 9. It's important, Justice Ponnen, you asked me a very important question.
Yes.
It's a very, very important question. It's key to this case. On page 904.
We know.
Because it's not unimportant. On page 901, the 4911 issue is dealt with.
And it's granted in the...
And it's granted.
But the judgment dealing with the
the
application...
the facts that came out in that 4911 application demonstrate, and I don't want to soapbox or score political points or anything else, but demonstrate, as Skippers J found in that judgment, that not only did Mr. Motsoeneng, let's call it, falsify documents, etc., but he lied to the court itself in respect of Mrs. Swanepoel. That was the finding. So what then Skippers says, Jay,
is Ms. Swanepoel's affidavit not part of the record?
there was a dispute between the parties as to whether the contents of the 4911 application should be part of the record. And our view was that it should be. We weren't responsible for preparing the record. And those who were responsible for preparing the record took the strong view that it shouldn't be, for whatever reasons, rightly or wrongly. And they put the Skippers J judgment in the 4911 application.
Because one sees a reference to that affidavit in the judgment on application for leave to appeal.
That's right.
And I looked through the record and I didn't find the
Correct,
affidavit.
correct, absolutely correct. And we find it strange that it's not there. And perhaps those who were responsible for preparing the record can explain to the court why it's not there.
Well, you
Not
could have supplemented it.
possible? Could have. But the point is this.
Not possible, it's a very real possibility.
Then I must take responsibility.
Yes.
But the point is this. This court can't ignore, with respect, or let me put it this in a different light. This court may take into account in deciding whether to set aside prayer 4 or the order 4 that Skippers J granted, that's which Skippers says in his 4911 judgment. He makes findings. It's before the court that was put up.
I think where you are now is talking about setting aside of prayer 4, which would be in dealing with the appeal. We were just exploring whether there is a possibility of, call it a postponement, in order to set up or to institute the disciplinary proceedings. It appears now that unfortunately you are not for it without the suspension part of the order.
I'm sorry, Giuseppe.
Now, I want to say thank you very much. Let's hear Mr. Marcus.
So, and just in answering Justice Mpoti, I was answering Justice Ponnen's question as to why there had not been a 4911. That was all I was asking.
Okay.
I mean,
No, we saw he forgot. It is
well,
there.
I would never say that. Yeah. As it is. So the reality is that the DA, in the public interest, submits, just to summarize, that whether there is a Part B or a disciplinary inquiry as to be the end of the suspension, without a suspension, the disciplinary inquiry...
Well, could I ask you this? That's not what the public protector said in the report.
That's right. That's correct.
She didn't say that.
She did not say that.
Well, I mean, she wasn't concerned. You're more concerned.
No. The question is, I think we've had the debate. The debates happened this morning. The question is, post-public protector, one has regard to, this is the point that I made up front, which I was criticized about. It's not about, this case isn't about the public protector only. It's about the public broadcaster, freedom of expression, the public interest. And the basis of that is the public protector's report, which has been ignored entirely and dealt with in an irrational manner. That's what this case is about. So this court can uphold Skippers J's order effectively on the Trencon line principles, that he had just and equitable powers on the facts, and he exercised them properly. He didn't go outside. And public protectors.
You are going to have time to advance that argument. Yes, Mr. Marcus. Yes, Mr.
Thank you, Justice Mpati. Justice Mpati, it's incumbent upon me to say immediately what our attitude is to the questions that you have put to the parties, and let me be unequivocal. The public protector supports the order made by the court below, directing that a disciplinary inquiry be held. That is absolutely consistent with and consonant with the finding that she had made, and she would therefore not be heard to oppose that in any respect whatsoever. In relation to the question of suspension, that formed no part of her report, and that is certainly not a matter on which she would wish to make any submissions. There is an issue of concern, however. It's not clear to us, of course, what the way forward is, whether there will be a postponement or whether this court will ultimately render a judgment.
You can proceed on the basis that there won't be a postponement.
I beg pardon?
You can proceed on the basis that there won't be a postponement.
Postponement. That's what I understood. Justice Mpati, on that basis, can I briefly take up the court's time? I would hope to try and be finished in about 25 minutes. To address really a single topic.
What does the order say admitting the amicus?
I'm not the amicus, I'm the public
protector. Oh, you're the public protector. I'm sorry. I'm sorry. I'll reserve that question for her.
Otherwise known as Mr. Trengove, is for the amicus. Justice Mpati, I would wish to advance really a single topic, but I would like to do it in two parts, if I may. The first part concerns the proper interpretation of Section 182(1)(c) and why we submit the public protector's findings are binding. And the second part concerns 4 counter-arguments which have been collectively advanced by our learned friends. I will just identify them and then answer them briefly. The first is that the public protector's powers are only investigative. The second is the alleged absence of wording in the Constitution which says that the public protector's decisions are binding. The third is what we would submit is the wholly misplaced reliance by all of the appellants on the Bradley decision. The fourth is the argument advanced by our learned friend, Mr. Maleka, on the role of Parliament. And there is finally one small aspect of the argument advanced by the Democratic Alliance concerning Section 41 of the Constitution, which we will submit is wrong. Can I capture...
Can I just say this to you? It seems as if Bradley has been given up. The ghost seems to have been given up.
I will say very little about it, but I would seek to reinforce the importance of not going down that line. And may I, with respect, submit, since Justice Navsa, you've raised it, that it resulted in really the taking of a wrong direction by the High Court. But I'll deal with that really in a minute. Our argument on the proper interpretation of the public protector's powers can be really encapsulated in 4 propositions. The first, and it's the obvious starting point, is the ordinary meaning of the words in Section 182(1)(c), to take appropriate remedial action. And what we submit is that in ordinary language, in very simple terms, that means the public protector is vested with the power to cure or to correct or to put right the improper conduct which she has investigated and to take an appropriate, to provide an appropriate remedy.
Might I put 2 things to you, Mr. Marcus?
Yes.
The one is that it certainly is more than you get in most comparative, comparable jurisdictions.
Yes.
So could I put the negative to you? I mean, I accept that, but I'd like to put a bit of a dilution to it.
Yes.
And it's this. It's not absolute, because part of the remedial power could very well be engaging. So do you accept that at least?
She's got a range of possibilities, of which that is one.
That is one. She could go to court to compel. Yes. She could go to Parliament. She could do ADR, or she could, either mediation or arbitration. So that's a range. Also is not entirely free from challenge, because let's assume she did something beyond her powers, that would be subject to challenge.
Absolutely accepted.
So can we then accept that, yes, it goes beyond what is ordinarily, what's comparable jurisdictions, but it's not absolute, but non-constates that it shouldn't be given thought to or be complied with, subject to a challenge of some sort that would eventually.
Justice Nafsa, there is no disagreement from our part on all of the propositions that you've put. In this particular case, we know, and I think Justice Mpati has drawn attention to it, that she relied specifically on section 182(1)(c), that is the prefatory comment. So that is, for purposes of this case, we are dealing with what it means to take appropriate remedial action. That does not by any means exclude the other possibilities that you've identified.
And you'd have to take into account the section that precedes that?
Yes.
Which sets out how the Chapter 9 institutions ought to be viewed and dealt with.
Correct.
And it would also be, tell can't wag the dog. This would inform the legislation, not the other way around.
That's absolutely correct as well, because what section 182(2) says, it envisages additional powers which can be conferred by legislation. So what we are concerned with in this case is an original power to take appropriate remedial action. But let me immediately address what has to be addressed, and it's the other provisions of the relevant section which have to be taken into account, all of which we support that interpretation. The second provision, apart from 182(1)(c), is of course 181(3), which envisages that the Chapter 9 institutions must be effective. And that is why the organs of state are required to assist and protect those institutions, like the public protector, to ensure their effectiveness. What we would submit is that to hold that the public protector's findings were not binding and enforceable would render the institution the very antithesis of effective. It would render them toothless. The third textual indication is one which goes to the legislative history. It entails a comparison between section 112(1)(b) of the interim constitution compared with section 182(1) and the other. It's the simple and trite proposition that a change in wording is prima facie a change in intention, and that the change in question with which we are concerned was designed to strengthen the institution. And the last of my four propositions really goes to the purpose of the institution of the public protection, institution of the public protector, as being one of those institutions that strengthen constitutional democracy.
Could we just do a short comparative, because nobody seems to have done it.
Yes.
I'm just interested in it. If you take the very first part of the Chapter 9 institutions is the public protector, right up front.
Yes.
Then you have the South African Human Rights Commission.
Correct.
You also have the Commission for Gender Equality, and then you have the Auditor General. Then you have the Electoral Commission, and you then have, right at the end of it, is the Broadcasting Authority.
Correct.
Now, if any one of those institutions made a decision, they couldn't be ignored, could they?
There are two critical differences between the institution of the public protector and the other Chapter 9 institutions.
Because there are hearings in respect of some of them.
I beg your pardon?
There are hearings in respect of, say, the independent broadcasting.
Correct. But there are two critical differences, and in fact this is partially my answer to one of the counter-arguments. The first critical difference is that the public protector is the only one of the Chapter 9 institutions which has got that specific power to take appropriate remedial action. None of the others have got wording which is the same as that. The second one goes to the
there may be a difference. If you have a broadcasting authority and they give you a license,
yes.
or they can they cannot give you a license, as it were. So there's almost a sanction there that's also quite onerous.
Yes. There is no doubt. I mean, the ICASA, as it's now called, which is one of the Chapter 9 institutions, has got very, very wide licensing powers and very wide investigative powers as well. It's not part of our case to suggest that these institutions are identical, but as I indicate, there are two important distinguishing features. The one is the conferral of that very specific power to take
in the Constitution itself.
In the Constitution itself. The second one, Justice Navsa, concerns the entrenchment of the office of the Public Protector, and there she and the Auditor General stand apart from the rest. In the original text of the Constitution, provision was made for the removal from office of the Public Protector by a simple majority of the National Assembly. That was one of the reasons why the original text of the Constitution was not certified. The text was then amended to allow for her removal only by a 2/3 majority. And in the certification judgment, which indicated why that simple majority was insufficient at paragraph 163, the court found that that simple majority was not sufficient to secure the independence and impartiality of the Public Protector, which was, and in their words, vital to ensuring effective, accountable, and responsible government. So that is what sets the Public Protector apart, and we would submit that all those textual indications point to the binding nature of her findings.
Nature, you know, we had that debate before.
Yes.
Because we I think, agreed it isn't absolute. Yes. And that's why binding is perhaps,
well,
Mr. Katz doesn't go that far. So binding is perhaps a bit confusing.
Can I use the long-standing administrative law terminology of having legal effect unless and until set aside? That is perfectly consistent with the argument we advance. Justice Navsa, if I may,
how did this terminology creep into the debate in the court below and in the judgment?
Justice Ponnen, I think I'm the only one here, together with my learned friend, Ms. Steinberg, was not in the court below, and I have no rational explanations for what happened there. So I can't answer that question.
Because that's normally not the kind of inquiry that one engages in.
No, of course not.
And terminology in the context of law can be particularly important.
Essential.
Well, could we just, whilst we're debating, and just keep in check for a moment Mr. Katz's fervour for Justice Kippers' judgment. Let's just, there are parts of it that seem at war with each other.
Yes.
Do you accept that?
Absolutely.
Because on the one hand he talks about it being binding, and then he says but, and then he says, so it's a toing and a fro.
I with great respect agree. I would identify the source of that confusion, if I may use that term, in the misplaced reliance upon Bradley, because that's where it comes from.
It starts with Bradley.
Starts with Bradley, yes. If I could then just deal very briefly with the counter-arguments, I've partially dealt with one already. Our learned friends for the SABC argue that the Public Protector's powers and functions are really investigative and nothing else. We have two answers to that. The first flows from this court's decision in the Mail and Guardian case, where in paragraph 17 it was made clear that her powers, or Public Protector's powers, are investigative and adjudicative. That is the first. The second is that it is really put beyond doubt by the Constitutional Court's pronouncement in the first certification judgment at paragraph 161, in which they said the new text clearly envisages that members of the public aggrieved by the conduct of government officials should be able to lodge their complaints with the Public Protector, who will investigate them and take appropriate remedial action. Now that is a textual argument with great respect. It is not simply an investigative institution. The second argument our learned friends raise against us is that there is no wording in the Constitution which says expressly that the decisions are binding. It gets back to the very point you've just put to me. I'm not wedded to that word binding. We don't have to use that terminology. I'm quite content to say they continue to have legal effect unless and until set aside. And what we would submit in that regard is that it's not helpful to look at inappropriate analogies. We don't suggest that the Public Protector is a court of law.
Could I ask you this?
Yes.
One of the arguments made a la Odekral
Yes.
is that, well, Odekral is really restricted to administrative decisions. and that therefore this isn't one such, and particularly I think they try to draw a line between the investigative role and not the concluding role. What do you say about that?
Two things, Justice Knapp. So the first is that, with the court's leave, my learned friend, Ms. Steinberg, will address the question of whether this is administrative action. In a nutshell, we submit that it is. But the second point is perhaps more important to the answer to your question, is that from the perspective of the, if I can call it the Oderkral principle, it matters not one iota how one characterizes it, because the rationale of the Oderkral principle rests in the rule of law, and it rests on the principle of not taking the law into one's own hands.
Well, it does go back to Volkhuis and Haneke.
Volkhuis, Haneke.
Haneke was the genesis. It was Justice Corbett.
Correct.
Well,
Correct.
Can I suggest this? On the assumption that this principle applies only in the administrative law sphere,
Yes.
and on the assumption that this is not administrative action that we are talking about, I struggle with this notion that in so far as the decision of an administrative functionary is concerned, that would continue to stand until set aside,
Correct.
irrespective of whether it's right or wrong.
Correct.
But that in relation to the public protector, who one would imagine has far greater esteem in terms of our constitutional model, that principle wouldn't apply to her.
It would be quite anomalous to draw a distinction which would result in a finding by her, given the wording of 182(1)(c) and the supportive text from the rest of those provisions, that they could simply be ignored.
Well, I'm saying even if one ignores textual interpretation of the Constitution and whatever, you take this principle, if it applies to an ordinary administrative functionary, more so one would think, would it apply to the public protector?
All the more so. With great respect, that would be our submission, Justice Pond.
So we probably don't have to get into classification, whether this is administrative
The
action
classification debate is certainly not essential for our argument on this point. I with respect agree with that. I said I would say something very briefly about Bradley, and if I may, I will. It is absolutely clear from that judgment that it turned explicitly on the peculiar wording of the Parliamentary Commissioner Act of 1967. The court...
You are now with Bradley.
We're now with Bradley.
Yes.
The court explicitly compared the wording in Section 10 of that Act with the provisions which were at issue in the other decision of the Court of Appeal, which is referred to R versus Commissioner for Local Administration, ex parte Eastleigh Borough Council. And the reason why the court entered that debate was because at first instance in Bradley, Mr. Justice Nolan had found that the finding of the Parliamentary Commissioner was indeed binding. And Justice Nolan had based that decision on the Eastleigh Borough Council case. So the court contrasted the wording with which it was concerned with that which was at stake in the Eastleigh Borough Council case, distinguished the two cases, and held that on the wording of Section 10 of the Parliamentary Commissioner Act, the Parliamentary Ombudsman was a servant of Parliament. In fact, the Parliamentary Commissioner was not able to initiate investigations itself. It could only investigate. At the request of a member of the House.
It's a much narrower focus, isn't it?
I beg your pardon?
The office has a much narrower focus.
Much narrower purpose, and it's absolutely explicit.
And to report back to the member with complaint.
Exactly. So I really need say, with respect, nothing more on Bradley, other than to say that the High Court was, with respect, misled by the role of the Parliamentary Ombudsman in a very, very different statutory setting with very, very different powers. If I may then deal with the argument advanced by my learned friend Mr. Maleka, which, if I understood it correctly, really suggested that the solution to the public protector's report and its enforcement and its binding nature was to be found in Parliament itself. Now, it is correct that the public protector is, by reason of section 181.5, accountable to the National Assembly and must, and these are the words, report on their activities and the performance of their functions to the Assembly at least once a year. What we submit in that regard is that, properly understood in the context of the section as a whole, this means really nothing more than the public protector must report on her activities and the performance of her functions. In other words, she must tell Parliament what she has done, how many investigations she's conducted, the number of complaints she's received, what her budgeting requirements are, etc.
Isn't it a bit like the NPA?
Yes.
I mean, the minister is the political functionary. They're an independent body, but they're accountable to him on a budgetary and other bits.
Exactly. Can I just wrap it up?
Well,
I'm sorry.
Sorry. In the first certification judgment, didn't the Constitutional Court say that Chapter 9 institutions must be manifestly to be seen to be outside of government?
Well, that's the point. What accountability to Parliament in this context doesn't mean, and emphatically doesn't mean, is that Parliament can second guess or interfere with the findings of the public protector in a particular
Isn't that
report.
part of the problem? I mean, the debate we had with your opponents earlier on, it's you can't have a watchdog. Then, where does it end? When you have parallel processes and several questions up the line, of course, again, it doesn't cut away the possibility of a challenge on legality or otherwise.
Yes.
But that's separate. You can't have the second guessing. You can't have parallel processes. But as I understood Mr. Maleka, he really was saying you've got to go through the section 52A to be
Of the Broadcasting Act.
Yeah.
That's a different argument. We say nothing about that. All we simply say is that it cannot mean that Parliament, in any guise, can either interfere with the independence of the public protector, can second guess the public protector's report. None of that. It's a reporting function and nothing more. And incidentally, the public protector is not even obliged in all circumstances to table her reports before the National Assembly. The only circumstances in which she's required to do so is if the Speaker of the National Assembly or the chairperson of the National Council of Provinces requests that the report be placed before either of those institutions. That flows from Section 8.2b of the Act. Finally, Justice and Party, I just want to briefly address one argument raised by the DA with which we agree. The DA argue in their heads at page 9 in paragraph 10 that one of the options that is open to a party, such as the SABC in this case, is to engage with the public protector to seek an amendment to her findings and or remedial action. And they locate that possibility in section 41, the cooperative governance provision of the Constitution. Now, that argument was rejected by the High Court. We submit rightly so. It was rejected in the judgment at paragraph 72b for the very simple reason that the public protector is not an organ of state within a sphere of government. It is independent of government. And secondly, the Intergovernmental Relations Act, which regulates section 41, explicitly excludes the public protector. We would simply add one further reason why that argument is wrong, and it is very simply this, is that once the public protector has issued her report, then we would respectfully submit that she is functus officio. There has to be an end to the process, and once that report is
That's
issued,
after interviewing everybody.
Oh, absolutely. Exactly. The mechanism, I think, is described in the papers or in the report itself. She does the investigation. She then publishes a preliminary report so that all interested parties can see what it is that she has in mind. They have the opportunity to be heard. They have the opportunity to persuade her that her preliminary views are wrong, etc. But then she issues the final report. Those are our submissions, Justice.
Mr. Marcus, right at the outset of your address,
yes,
you said what you would abide and what you wouldn't abide.
Yes.
Can I just ask you pertinently, and take your time, and perhaps we can engage about it a bit more lengthily than we otherwise would. But if we were to incline in favor of maintaining that part of the High Court's order that relates to the inquiry,
yes,
and not the suspension, and as I understand it, that was what Minister Karim was, from the papers, that was what Minister Karim was asked to do by the public. No more, no less. Your client would abide that.
Absolutely.
Would abide that. Could I just ask you something else, and perhaps just for assistance, and perhaps the amicus can say something about it. The public protector's report was the very genesis and basis for the DA's approach to court.
Correct.
One would think that if we incline to an order as I put to you, that would vindicate her position.
Yes.
And that's what she would abide.
Yes.
Well, that would be a complete vindication.
Yes. The only rider I would add, and I do it with great diffidence, is that the public protector is very concerned about the reasoning underpinning that order in the High Court judgment. And she, in fact, says in the affidavit supporting, in the affidavit that she put up in the leave to appeal.
Go a bit slowly, Mr. Marcus. Let's see what her concerns are.
The concerns are this, is that the judgment of the High Court, sorry, I should tell you where she says this. She says this in volume 4.
She filed an affidavit subsequently.
Yes, it's, I think it was in the leave to appeal.
It's round about page 740.
It's the passage that I'm after is on page 745, and it's paragraph 24, where she says this. This matter represents yet another example of what would appear to have become a trend amongst politicians and organs of state to simply disregard reports issued and remedial actions taken by the public protector. It is accordingly of critical importance, both for this matter and in general, for the legally binding effect of reports of the public protector, including that in issue to be confirmed.
Well, could I just,
yes.
We're now having been advised by you after the debate,
yes,
we'll change that terminology about the legal binding effect to the
I don't want to be wedded to the terminology. It's the underpinning principle, and my instructions, because we all took instructions during the adjournment, is that the trend that is described there has continued. It has had another potentially chilling effect.
Well, could we perhaps not discuss other cases, Mr.
No, it's a general proposition. And let me put it at the level of generality, is that, I'll put it at the level of generality. If potential complainants understand that the reports of the public protector can simply be disregarded provided there is a rational basis to do so, it really renders the body toothless. And I would submit, and I'll make this by way of submission, that it would really considerably dilute the effectiveness of the institution.
Could I ask you this? You heard your colleagues say that they didn't seriously contend otherwise than it couldn't be ignored, that they appeared to be at idem. That's as I understood it. Perhaps
they're all at idem, but Justice Navs, they're all at idem on the strength of Bradley. Now, we know that rationality is the minimum threshold that is required for the exercise of all public power. In relation to the report of a public protector, all that it would take to meet the low threshold would be for an organ of state to say, well, I disagree with her evaluation of this piece of evidence, or I would have given more weight to that evidence and less weight to this evidence. That's the kind of thing that passes the rationality threshold. And that, we submit, is the effect of the High Court's judgment, which is wrong.
Could I ask you again for your assistance, and
Yes.
if you want to leave it just to Steinberg, you may, but I'd value something from you. If you heard my brother Swain put the particular passage to, I think it's paragraph 95,
Yes.
to your colleagues before you. Now, if we let's strip it of all the other stuff lower down, but the very essence of the top, which is really the test for an interview, we could come to the conclusion that you say your client is happy.
Yes. Yes.
Okay.
Thank you, Justice Mpati.
Yes. This is really what we don't want. Just not enough stuff like court is yeah. Yes, Ms. Steinberg.
Justice Mpati. Corruption Watch 2 would support the order suggested by the court.
Sorry, I can't hear you, Mr.
Corruption Watch 2 would support the order that has been suggested by the court. We too, however, must express our discomfort with the reasoning in the Skipper's J judgment standing. The reasoning that leads to the conclusion that, in effect, the findings of the public protector do not have legal effect if the state organ thinks they
Held a different view.
Holds a different view.
But do you align with Mr. Marcus on that?
Yes, I would just add to that and say, and the court doesn't have to turn there, but in Corruption Watch's affidavit to apply to join this court, at about paragraphs 12 to 15, we emphasize that one of our key roles is to foster tools with which civil society can defend itself against a rising tide of corruption. And Corruption Watch works with complainants who complain about big and small issues all the time, and then works with the Public Protector's Office to process these complaints. And that the effect of a judgment that says that the state actor may, in its wisdom, decide to ignore this, has a deeply chilling effect on our work and on our capacity to empower civil society and motivate civil society.
Your real problem is you don't want a toothless watchdog.
Exactly. And we do appeal to this court to, in the order that it makes, however limited in terms of the huge scope on these papers, to say something about the reasoning of the court below in that regard. We don't want to stand.
It's very difficult, Ms. Steinberg, and I say it with deference. I understand the pressures the High Courts are under, and I understand the volumes that they deal with. But it's very difficult to find a consistent thread in the reasoning that leads to the conclusion, because it goes up and down. Do you agree with that?
With respect, I do.
And you
so
say it's much...
so it's not logically consistent. If anything, the judgment is internally contradictory.
With respect.
So what you would do is a linear argument. This is the Chapter 9 institution. These are its constitutional powers. This is part of where it fits into the scheme. The conclusion is that whatever it does, absent a challenge of some sort that undoes what it's done, it has legal effect.
Absolutely.
Because once you take value out of the equation, you take out what underpinned the whole reason of the High Court.
That is our view with respect. And we support all the submissions of Mr. Marcus, and I plan to repeat none of them. I want to add a point here and there along the way to build up that linear argument with this court's permission. And I certainly don't propose to take more than the 15 minutes that an amicus is usually given.
You see, Ms. Steinberg, I'm doing this for the benefit of counsel who argued first and who said that yes, we don't have a difficulty with you saying, that's me and my colleagues, that the direction of the public protector cannot be ignored. We might have misled ourselves or possibly misled counsel as well. But what we meant, let me speak for myself, what I meant is that it cannot be ignored. You've got to do something about it in the sense of you comply or you challenge it. And I had in mind that you could even engage the public protector in order for it to amend. But there's an argument now by Mr. Marcus that says it may well be an argument that says when she has issued a final report, she's functus officio. I would have to apply my mind to that, but that's not how I looked at it. But what I'm trying to say is that, and I'm hoping that counsel will indicate to us what they were accepting, that you cannot just ignore it, and it's not a question of whether it is rational or not rational. It's a question of it exists, it has legal effect, you've got to do something about it.
That's helpful. Thank you, Justice Mpati. May I add one or two points in that regard? In our heads of argument, we point out that the term appropriate remedy, has been explored quite extensively by this court and the Constitutional Court in another context, the appropriate relief that our courts grant. And that there are really two adjectives that come up most often as describing what appropriate means. And the first is effective, and the second is suitable. The dictionary definition is also suitable, as we point out in our heads. Suitability comes up in the Sanderson case of the Constitutional Court. And the court says suitable means it says appropriateness requires suitability, which is measured by the extent to which a particular form of relief vindicates the Constitution.
So just repeat that.
Appropriateness requires suitability, which is measured by the extent to which a particular form of relief vindicates the Constitution and acts as a deterrent against further violations of rights, which is a similar ratio to FOSI, which says effective relief, appropriate relief, must necessarily be effective, and its efficacy is aimed at protecting and upholding the Constitution. So when we look at Section 182 and the phrase appropriate remedial action, we are looking at effective or suitable remedial action that at the end of the day vindicates the Constitution and acts as a deterrent. The Constitutional Court has developed a victim-centered approach to remedy in this regard, and there are many dicta to that effect. From the point,
surely we don't look at it ex post facto. In other words, it's for the public protector to make that determination.
Yes, but the point that follows, Justice Ponnet, is that without the longer, sharper teeth to which your brother refers, it's ineffective.
if she makes that determination, and if in fact there's acceptance that it cannot be ignored, well, that's the end of that inquiry, isn't it?
With respect, I agree. I think one point that has been perhaps overlooked by all of us in that regard, we all seem to accept that the public protector's decision is an exercise of public power. We don't need to determine today whether it's administrative action or whether it's another form of exercise of public power. We would argue it fits quite squarely.
But it's being exercised.
But public power is being exercised.
And there's a result, there's a conclusion.
That has, as my learned friend Mr. Marcus put it, it has a legal effect until it's set aside. What we haven't interrogated is whether the state actor at whom this exercise of public power is directed, whether their response is an exercise of public power. In the judgment of the court below.
Let me just understand that.
Yeah.
Are you talking about the responses by the minister and the board
yes.
to the public protector's report?
I am Justice Navsa. And in paragraph 71 in the judgment of the court below, the judge says there can be no question that a decision whether or not to accept the findings or remedial action of the public protector constitutes the exercise of public power. He just says there can be no question. He doesn't substantiate that. He says it is a requirement of legality that decisions must be rationally related to the purpose for which the power was given. And then he says, on that basis, and using Bradley, he says, well, if that exercise of public power must be rational, the public protector or the complainant can come and review it if it's not. But that is presupposing that it is an exercise of public power. And we would submit that it's not. And that's another basis on which, legally speaking, his judgments are untenable.
What would you submit is not an exercise of public power?
The minister or the board's decision to ignore, abide, what to do with the finding of the public protector. Can I just advance my argument?
But if they have two choices, accept or apply to court to review,
yes.
Does it matter?
Whether it's public power or not?
Yes.
No, it doesn't. It doesn't.
Aren't you making the argument a little too intricate, Ms. Stein? You've been okay up to now in terms of keeping high up to now. I just have a difficulty with where you're going now because the argument's been fairly linear. I've kept up. Maybe it's just that I'm obtuse, but it does seem to me that you're now convoluting it when it doesn't need to be convoluted because I don't know where it takes you. You say, well, this is what the public protector's done. Whatever their response is hardly matters. What they haven't done is they haven't undone the exercise of the public power that she's exercised.
Yes.
Isn't that correct?
Yeah, and I thought you were saying that we don't need to go into that, and I think you are now going into it.
Then I think I'm trying to cover all my bases, and perhaps too thoroughly. I think the rest of our arguments are probably then too complicated. My learned friend is saying, sit down when you're ahead.
Less is more.
It's the theme of the day.
Well, to put whilst you're ahead is always good advocacy.
Yes, thank you, Steinberg. Now we're getting to you, Mr. Katz.
Yes, thank you. Thank you, Justice Mpati.
Mr. Katz, you say the order is binding unless it's set aside.
the remedial action. We say that in paragraph 9, the word, well, we don't say the word binding. We say, yeah, absolutely.
Yeah, you don't align with the binding argument. You distance yourself.
It has to be obeyed until set aside.
I think it's beautifully captured, if I may say, in paragraphs 8 and 9 of our heads.
So you beautifully captured
in our submission, with respect to the drafters of our heads.
All we can do is stare at you with adoration.
Not me, but my learned friends. Anyway, the point is this. In paragraph 9.1, we say, first, the DA supports the submissions by the Public Protector and Corruption Watch that it must be complied with unless, etc. But if one turns back to the previous page, on page 5, we say, framing the question in this way, the binding question, may be misleading. The question should not be, is remedial action taken by the Public Protection binding, which is what the debate's been today. The real question we submit is, how does the Constitution require an organ of state to respond to remedial action taken by the Public Protector? And then what Corruption Watch and the Public Protector say are what we say. So that's the DA's position. As far as Bradley is concerned, we agree entirely with...
Before you get to Bradley, and whilst we're still here, can you just deal with this further engagement point that you...
Yes, I do.
And that's in the context of Mr. Marcus's submission about Funkus.
Yes, I will deal with that. I've got 2 points to make on that in that context. The first is, in paragraph 9.5 on page 8, there's our 5th question of prior engagement. The respect for the Public Protector demanded, 181.3 of the Constitution cannot permit non-compliance through an action or failure. Then the important sentence that Mr. Marcus takes issue with us on. It is also entirely inconsistent with the principles of, and then footnote section 41. And he says that's wrong. All that we say is that to the extent that section 41 requires cooperation, it mirrors section 181.3, and there's no, and we don't say that 41 governs. It's neither here.
I mean, let's again, let's not get Byzantine. I mean, as I understand it,
yes.
What my brother Swain put to you, you accept, and that's the beginning and the end.
And to answer I agree with Justice Nafsa. We with the Public Protector.
I was raising with you what's contained in paragraph 9.1, your point 8.
The answer to that is this. This is a good example, this case is a good example of that type of consideration. The Public Protector takes remedial action of certain kinds, and some of them, I say some of them, may require some type of rational engagement before there can be proper implementation. So then if one takes the particular one, I think Mr. Monetti referred to it this morning, the question of the paying back the monies for those which had been lost through maladministration, it may be appropriate, and this is our point about further engagement, the functus point that your Justice Ponent puts to me, it may be appropriate in circumstances for the requirement of the organ of state to engage rationally to satisfy the remedial action.
No, but then you talk about altering the remedial action.
To the extent that that was a slip-up.
What you say at 8?
This is 9.
Engages with the Public Protector and convinces her to alter the remedial action. Now, if Mr. Marcus is good on the functus point, and I'm not sure, but if he's good on that, then of course once the Public Protector has finally spoken, there can be no further engagement to convince her to change.
I have to say, Justice Ponent, on mature reflection, we go with Mr. Marcus.
It could indeed be so, because if there is an interim report, as it were, to give people a chance to engage, respond, then once he issues a final report, then that may be it.
Justice Mpati, you hit the nail on the head by the first word of your sentence, if. This Public Protector is an outstanding example of the office. It doesn't mean to say that the Public Protector, by virtue of the Constitution or legislation, is required to produce an interim report for purposes of further engagement.
But Mr. Katz, just again, you're over-eating the pudding. Let's just start again. My brother presiding and my brother Ponent put you. You've got, we're now fact-bound. Fact-bound is there's a process. The process has led with exchanges with, let's use a South African word that annoys me, but it's stakeholders. You've now engaged stakeholders. everybody's been engaged.
Terrible word.
Yeah, but we've now all been engaged. Everyone's had their say. If the curtain doesn't come down, we'll never have an end.
At
some stage it's got
we're
to...
with you. We're with you.
Yeah.
So the DA are with the Public Protector and with Corruption Watch on that. We don't deviate at all.
Well, if you've aligned yourself with Mr. Marcus, safety in numbers, I suggest, Mr. Katz.
As it pleases the court. As far as Bradley is concerned, the question arose where did Bradley come from? It certainly didn't come from us. We had never heard of Bradley until the judgment came out.
Does it matter where it came from?
Well, the point is it doesn't matter, but we certainly don't want to be responsible for the introduction of, let's call it an alien branch, which doesn't fit in with our particular constitutional jurisprudence. So I just wanted to make that clear, that to the extent that we hold Skipper's judgment to our breasts, we really don't hold the judgment, we hold the order. And that's what I'm going to come to.
I suppose it would be much better to say Skipper's J.
It's Skipper's J, I do apologize. Skipper's J's judgment. We don't hold his judgment to our breast, but we hold his order. And his order one finds on page 834, 835. And I think it's important, we submit that it's important from the DA's perspective that the court considers the appeal in light of the regular appeal considerations and says, well, what is being appealed against? And these are the 5 orders that are being appealed against. Leave aside the Bradley difficulty, which we go with the Public Protector and Corruption Watch. And we go with the notion that to the extent that Skipper's J misdirected himself on the question of the powers in his judgment, that didn't...
I'm sorry, just slow down.
To the extent that we
just
accept...
lost you, that's all.
Yes, I apologize. To the extent that we accept, which we do, Corruption Watch and the Public Protector's criticism of Skipper's J's analysis of the powers of the Public
Are you
Protector...
loosening your grip from your chest?
No, the order. We hold on to the order. The fact that he misdirected himself on the question of the powers doesn't taint the orders that he granted for purposes of this appeal. And that's all I want to make. That's the only submission that I want to make this afternoon. And when one has regard to the order...
Bound by the Public Protector's report until it's set aside that it must logically follow the disciplinary proceedings must be ordered.
Correct. Yes. And then the question is, assuming for the purpose of the debate that he did misdirect himself on the question of the powers, but he granted the correct order, let's say in 1, which would be the natural consequence.
The suspension.
No, 1 is the disciplinary inquiry. Right. The other orders, that's 2, 3, and 4, which are 2, that an independent person shall preside over the disciplinary proceedings. That's not in the Public Protector's report.
No, but I don't know that's an issue. It doesn't seem to me, the time limits in the disciplinary inquiry don't seem to be an issue. Maybe Mr. Maleka and Mr. Malichi will tell us otherwise.
Sorry, I'm talking about the order 834 little a, which is order 2, not
yeah,
Pred.
Yeah.
Sorry.
You're talking about 2, 3, and 4.
That's right.
Yeah.
The Prayer 1 mirrors the Public Protector's remedial action.
Yes,
It's identical.
but the others don't.
It's,
But the subsequent orders
yes,
don't.
that's right.
But they're ancillary orders.
That's right.
And so if one is good and if it can be defended, one can hardly imagine that anyone could quarrel with 2, 3, and 4.
That's our submission.
Yes.
That's our submission. No more, no less. That's our submission.
It's
And 5 for that matter.
Well, I've tried before, Mr. Katz. I'm going to try one last time with you. The Public Protector and Corruption Watch want no more than what was suggested. I'm going to put it to you again. The very basis of your approach to court was the Public Protector's office. Fine institution, as you say it is. Why should we go beyond what formed the very basis of what your approach to court?
Now, I'll answer that on 2 levels.
Yes.
The first level is, on the facts you should, for the reasons I'll come to. But on the second level, in order to come to the conclusion as to whether you should or not, the real test would be, did Skipper's J misapply 1721B? And we submit strongly that there can be no suggestion that if 1 is good, 2, 3, and 4, and 5 are not just and equitable, appropriate, effective remedies for purposes of 1721B.
That's a question of what view you take of what Skippers did of the facts, because if the facts were that the Public Protector's report said no more than X, and Skippers went beyond X and didn't understand that he was doing so, you could rationalize it any way you want.
No. With respect, Justice Nafsa, it's not a question of rationalising. Because what Skippers J does, he misdirects.
Can we just pause for 1 second? The thorny issue seems to be 4.
Yes, that's correct.
Yes.
The thorny issue seems to be 4.
That's correct.
Okay. Now, let me just put, and I raised this with you earlier, and I said, forget about the technical niceties. Let's look at it pragmatically. You could get a judgment from this court, or there could be what in effect would be an order by consent, in terms of which parties agree to institute disciplinary proceedings. You get a judgment from this court, which in itself may be susceptible to further appeal to the Constitutional Court. Now, you could postpone the evil day that way, or it could be a settlement of the principal issue on which you went to court, and everybody could walk away from it. So think about that.
Could I ask you to add to that, put in the mix in respect of the following? What did we do in respect of the hanging review, which is still there? I mean, just for consideration between the parties. So there's the review that runs alongside it, plus the disciplinary part. So when you're making when you're considering that, consider that in total. And as my brother Ponnen put to you, if you had an order by consent, there would be finality within certain parameters. If you didn't, who knows where it'll go and how long it'll go. And that's what you've got to think.
Let me answer Justice Ponnen and Justice Nafsa both issues right now. We've considered both issues. That's prayer for, the key difficulty, and we've considered the second difficulty that's raised is where does Part B go? And in both instances we say prayer for is appropriate. On the facts of this case, on the facts.
We've heard you, Mr. Kitts. Yes. That's not what's been put to you.
And where it goes from here, if it goes, is something for that forum, fora, wherever to go.
Mr. Katz, we're at cross purposes, and you can be as adamant as you like. We were trying to find a practical solution that would suit everybody for finality in this, including the institutions which we believe are valuable to us. That's all we're asking. So you can be as adamant as you like. That's not what I'm asking you to engage in.
No, but our submission, I'm going to be adamant with respect on this issue. We submit that the public interest is served by prayer for. Not a question on the DA. The DA come here in the public interest. And we submit that...
Is it better served by awaiting a judgment from us which would deal with prayer for and may or may not be granted, or a settlement today which says there would be a disciplinary inquiry with a necessary time frame, I would imagine, that the parties can agree on?
The simple answer is we submit the public interest suggests the former.
Well, you've made your position.
I've made it. I mean, and if one has regard, there is one fact that I do want to touch upon. And it was a question that Justice Ponnen you raised this morning on this issue. On page 748, in volume 4, the public protector says, that she wishes to clarify the following. This is the point that you're...
748 is where we are.
Sorry, 748. 32.1. The former Minister of Communications, Mr. Yunus Karim, undertook in Parliament to implement the remedial action as contemplated in the report. This was, however, to my knowledge, not in fact done. And then it goes on. And the board of the SABC also on more than one occasion indicated that it was engaging with the report and sought extensions in order to comply. The extensions were granted, but I expressed concerns to the chairperson with regard to the time. Attached copies. Notwithstanding the indications of the chairperson in the attached letters, and that an implementation plan will be provided, in substance, no plan has been provided and has been in compliance with only one remedial action. Now, I just want to emphasize the following. This morning we heard an argument from the Minister to the effect that Broadcasting Act gives proper place not to the court, but to some other body to deal with questions of suspension. And I want to answer that argument on a constitutional court judgment dealing with water. It's a case called...
Mr. Katz, sorry, you're losing me a bit, because as I understood it, you were addressing something my brother Ponnen put to you, but we seem to have veered off the track here a bit. because that's not, as I recall it, the question he put to you. And I'm just trying to figure out if I'm missing something, or...
The question put to me is...
No, but I understand that. But I mean, you know, we've understood that. That's not what we've been trying to engage you.
No. Perhaps I missed the question, but perhaps Justice Bonnen...
No, I think you answered my question. I think we agreed that you were hell-bent on getting four as well.
The submission is that the public interest, before is served by the public interest. I just want to make one other point on this question of suspension. When you suggested that the High Court usurped the power of the proper authority to suspend, the court heard that argument this morning because of the provisions of the Broadcasting Act. Now, in this case, it's called Mazibuko versus the City of Johannesburg and others. It's reported in 2010, Volume 4, South African Law Reports 1 at CC at paragraph 96. There was a complaint by the Mazibuko applicants that the water policy of the City of Johannesburg didn't satisfy constitutional demands. Went to the High Court, who upheld the complaint. Then the case went on, and by the time it got to the Constitutional Court, the City of Johannesburg had changed its water plan or policy to satisfy what would be a constitutional setting. And the complaint at that stage before the Constitutional Court by the Mazibuko applicants was it's unfair to them because when they came to court, there was a policy which was bad, there was litigation that triggered the proper policy, and now we're before the Constitution. And the Constitutional Court responded by saying the following, and it's in response to Mr. Maleka's point about this litigation having stopped the engagement in effect. And the point that the Constitutional Court says is this in paragraph 96. It may well be, as the applicants urge, that the city's comprehensive and persistent engagement has been spurred by the litigation in this case. If that is so, it is not something to deplore. And then it goes on, in respect of socio-economic rights. The litigation will in that event have attained at least some of which sought to achieve. The point I make is this, to the suggestion that the National Assembly or the Minister were precluded from continuing to engage with the public protector because of the litigation.
No, but Mr. Katz, I mean, I don't know where this is going because I understood the argument. Let's go back. You align yourself with Mr. Marcus. You align yourself with Steinberg. We've gone that route. We've cut out, their argument has cut out Mr. Maleka's reliance on the sections. They say it's got nothing to do with it.
No, we agree.
Section
paragraph 4
so where's this going to? If it's your concern, I mean, it seems to me that it's your concern that if you reach what my brother Party put to you in respect of a practicable solution, that will be addressed and somehow Mr. Maleka will get that as a qualification. Well, I don't understand that we get there if you follow the Marcus Steinberg.
Perhaps we're talking cross purposes. I'm dealing with Justin Ponnen's question about Order 4 of Skipper's J's order. Only that's what I'm dealing with.
No, but I understand what you're saying is that if you don't give it, you'll be caving in to what Mr. Maleka said and what Mr. Maneche said. Because really, in effect, you'd be saying that resides only with the minister.
The suspension order.
Yes, well, but I mean, there's no way if Mr. Marcus and Mr. Steinberg's views are sustained that one even gravitates towards it. And if that's your concern, well, then it shouldn't be a concern if their views prevail.
Well, their views don't deal with, so with respect, Justice Napster, they don't deal with Order 4. They're silent on it. They say, if I understand if I misunderstood their argument, I apologize.
Mr. Katz, you know, I'm sorry, but I'm going to try one last time, and then I promise I won't say a word. Try just one last time. Mr. Marcus made the argument. Mr. Steinberg made the argument. They were very linear, easy to follow. You aligned with them.
That's right.
Your insistence on the suspension part seems to be born out of a concern that somehow Mr. Maleka's view about where the right path is and where the only suspensive power is will somehow triumph or will be a qualification. Well, if their views prevail, you don't get to that position. So if for a practical solution, what my brother presiding put you as a practical, if that's your concern, well, that ought not to be concerned if your view prevails.
I have to be honest.
Outside of the suspension section.
No, outside the suspension section, of course. I'm only talking about suspension. I'm only dealing.
I give up. I give up, Mr. Mr.
I'm not sure. The only issue I'm talking about now at all is suspension, nothing else.
You've said the public interest demands suspension. That's your argument.
It's the argument.
Whether you start with the disciplinary proceedings tomorrow, you just want the suspension.
I'm not going to. Mr. Motsoling, he criticizes me for being, criticizes me personal level for being dramatic in the court of court. Let me just, I need to just, last thing before I sit down. There's reference to OTA by our learned friends. I would wish to give the court two cases of the Constitutional Court which post-date OTA, which suggest that the reliance on OTA for the purposes of suspension is not good. The one is a case called Minister of Home Affairs and Others versus Johnson, and it's reported in 2015, 6 Butterworth's Constitutional Law Report 707.
That was a bit too quick. Can you just repeat it, please?
I have a copy of it actually for the court, so maybe I should just read through the paragraph. It's 2015, volume 6, BCLR 707, and particularly at paragraph 7. The second is called the South African Informal Traders Forum versus the City of Johannesburg. It's 2014, volume 4, SA Law Reports 371, CC, and particularly at paragraphs 25, or 24 and 25. So the suggestion, and a suspension is simply, it's an interim interdict. And the principles of interim interdicts, set legela, as Justice Nafsa pointed out this morning, have not been altered by OTA.
Well, then you must make up your mind about whether it was final relief or not.
Would it be appealable then?
Sorry, Justice Nafsa. The prayer 1 is final, I accept that. The suspension is not. Suspension is interim. And I'm asking for an interim interdict pending the resolution of those which are contained in prayer order 1 of Skipper's J's judgment. It's interim. It's precautionary, it's not disciplinary, and we would submit that the Trencon case, perhaps I need to go back to Trencon. It's important. 2015, volume 5, SA Law Reports 245, at paragraph 82 and follow. The Constitutional Court says, there's a heading, the standard of appellate court's interference. Regardless of the merits, Trencon argues the Supreme Court of Appeal's order should be set aside on the basis that it has no power to interfere with the High Court's order. Trencon decides to find a gripping ground for this argument in the nature of the discretion conferred by Section 8.1 of PAJA, which Trencon claims to be a discretion in the true sense. And then there's a debate, paragraphs 83 and following, as to the distinction between discretion in the true sense and the loose sense. And all our submission is this, that paragraph 4 of the order was an order made by Skipper's J in the true discretionary sense, that is, as 1721B of the Constitution, just and equitable discretionary power.
We understand that you've made the proposition, and you've said it 100 times, that there's narrow grounds for upsetting Skipper.
As it pleases the court. So that's our argument as far as prayer 4 is concerned, or order 4 of Skipper's J judgment. So we submit the appeal should fail in respect to all 5 orders with costs, and an appropriate order of costs, including the costs of, we've said in our heads of argument 3, but we would obviously accept 2 on the basis of the usual rule, as it pleases the court.
Thank you.
Thank you.
Justice, I intend to, in reply, to deal only with the issue of suspension. In respect of the question of the powers of the public protector, since the parties abide the order regarding institution of disciplinary proceedings, I do not have to make any further submissions to the court. When the court looks at the powers and the comparison with the other Chapter 9 institutions, the court might want to look at the powers of the Human Rights Commission under Section 184, sub 2, sub B, which empowers it to take steps to secure appropriate redress where human rights have been violated, which is comparable to the other power of the public protector. But that's just for the assistance of the court. Now, in respect of the question of suspension, I want to refer the court to the full judgment and read some passages from that judgment, and then also address the reliance on the Trencon decision, which, as we understand, our learned friend says the judge, Skippers J, exercised a true discretion in granting prayer 4, and in consequence, this court can only interfere in limited circumstances. Now, one of those circumstances, which is well established, is that the court can interfere if the discretion was exercised on a wrong principle. And I want to submit to the court that in light of the full judgment, indeed the granting of prayer 4, we submit, was on a wrong principle. And this is this. At paragraph 48 of the judgment in full, it's NDPP versus Freedom Under Law, 2014, Volume 4, SA 298. The court was dealing with the powers of the commissioner to institute disciplinary proceedings and to suspend a member of the police. And what the court said in paragraph 48 is the commissioner's powers to institute disciplinary charges and to suspend members of the police derived from regulations published under the South African Police Services Act of 1995. These powers can be tracked back to Section 207(2) of the Constitution, which requires the commissioner to manage and exercise control over the SAPS. These powers are clearly public powers. That is why they were promulgated by law and not merely encapsulated in a contract between the parties. The commissioner took the decision to institute disciplinary proceedings against Mdluli and to suspend him pursuant to these powers. And then the court reviewed and set aside the exercise of those powers for various reasons set out in paragraph 49.
Could I just ask you, Mr. Manichi, if you have regard to what the judge in the court below said? Yes. Wasn't the whole gravamen of his judgment that what the public protector said has to be given effect?
That's correct. We accept that.
And what the public protector said stops at point X and not point Z.
Yes.
And that's your argument.
That's our argument, but I'm adding a further argument, Justice Nafsa, and it's this.
This seems to be lost in the wash. Why would that order in isolation be appealable?
Well, in the interest of justice, we submit it can be in terms of the outer judgment, because
it's pending finalization of the disciplinary proceedings, he is suspended. That's an interim order. It's classically an interim order.
Well, that's correct, but outer says where it affects the separation of powers, and that is my submission. That the court,
how would this affect the separation of powers?
Well, it is this.
Whether or not he's suspended.
The power to suspend, in terms of the Broadcasting Act, Section 15, 2, capital A, sub 2, that power is given to the appointing authority, which is the minister. And now what the effect of the full judgment is this: where the power is given to a specific authority, as in this by law, by legislation.
Could we just work it out?
Yes.
If I understand it correctly, if the public protector's report had been given effect to, what would have happened is there would have been a disciplinary inquiry. We're just working it out now notionally. There would have been a disciplinary inquiry. That disciplinary inquiry would have come to a conclusion. That conclusion might have led to a recommendation by the board to the minister. Is that correct?
The disciplinary, yes, would have led the outcome of the disciplinary inquiry, if it was to terminate, would have had to go to the minister.
What that would do is it would lead to a recommendation to the board.
Yes.
To the minister.
That's correct. But even the suspension under the section that I was referring the court to, perhaps I should refer to that section and just read the provisions of the section. It is the Broadcasting Act, and that's dealing with Section 15, capital A, which is headed Resolution for Removal of Member, Dissolution of Board, and Appointment of Interim Board. And Sub 2 deals specifically with the question of suspension. It says in Sub 2, the appointing of body, which is the minister in this case, A, may suspend a member from office at any time after the start of the proceedings of the National Assembly for the removal of that member. So I think the question being put to me is, when would the proceedings to suspend start? Yes. So if there was an institution of disciplinary proceedings, The board could.
Might have been something that the public protector was alive to. I'm not entirely certain, but it might have been something she might.
Well, the public protector does, in her report, refer specifically to the, it's in volume 1, to the, sorry if I can just get that, because of the name.
You've mixed up files.
It does specifically refer to the personnel regulations. Sorry, I beg your pardon. It's in volume. It's in volume 4. In volume 4 is the actual regulations. What I wanted to refer the court to is where in her report she refers specifically to the personnel regulations. But I can make the submission is that she refers to the personnel regulations which require that if there's to be suspension, there must be a hearing, and those personnel regulations you'll find in volume 4 at page 661.
Mr. Maliki, I'm not sure that you are correct in saying that the only person who can suspend is the minister.
No.
You see, and you're referring us to section 15, capital A2.
Yes.
A. The appointing body may suspend a member from office at any time after the start of the proceedings.
Yes.
Start of the proceedings, which proceedings? The proceedings referred to in 1, isn't it?
That's the proceedings to remove.
To remove.
Yes.
So that's the suspension that's talked about there.
Yes.
It doesn't say if and when there is any inquiry insofar as his job description or whatever he's done at his job is concerned, the only person who can suspend is the minister.
That is correct.
Because you've got to start the proceedings to remove him or her.
That is correct, Justice Bhatti, that the suspension in that context is when the proceedings to remove have started.
Exactly.
The other form of suspension is the one I'm referring to in the personnel regulations of the SABC.
Yes,
which,
I know.
Which require that the SABC must conduct a hearing.
Yes.
Now, the wrong principle I'm submitting to the court is this, that in the full judgment where it deals with appropriate remedy under paragraph 51, it says that before the court, perhaps I should read further about 10 lines from below, that where the court says, suffice to say that in my view, this is not one of those rare occasions, and I can find no compelling reason why the executive authorities should not be given the opportunity to perform their constitutional mandates in the proper way. In other words, let them first decide whether they're going to suspend or whether they're going to continue with the disciplinary inquiry, and only when they have made a decision which is open to review, challenge that decision. Now, what happened in the High Court? You had the DA, in circumstances where the public protector has not asked that the SABC or the minister suspend Mr. Mutsoeneng, simply that they must institute a disciplinary inquiry. In that context, asking the court to suspend Mr. Mutsoeneng without allowing the functionaries to make the decision themselves first, and if that decision is open to challenge that. So my submission is the appropriate order for the High Court in respect of suspension should have been to refer the matter to the public authorities, that is the minister and the SABC, in light of the judgment of the court.
The disciplinary inquiry, the order in respect of the disciplinary would take care of that.
I'm talking about the suspension.
Oh, no, okay.
Yes. In other words, the court orders a disciplinary inquiry to be instituted, but as to the question of suspension, it refers that back to the minister and the SABC to properly exercise their discretion on taking account all relevant circumstances on whether a suspension is required. Because a suspension is determined by a consideration of a number of factors, including the business interest of the SABC, the interests of Mr. Mutsoeneng, the public interest, and it's only when that decision is not taken properly that the court controls that by way of judicial review. But what the court did, it was readily assume the function of the suspending authority. And we submit in doing so, usurp the powers of the SABC and the minister, both under the Act and the personnel.
With regard to labour law principles, you'd have been entitled to be heard on the suspension.
So says the articles, isn't it? Or rules that an employee would have to be given an opportunity to put his case.
Absolutely. And one can't say the High Court proceedings were suspension proceedings because that is the province of the employer or the minister being the appointing authority.
I think what you were looking for is at page 661 of that.
661. Yes, that is correct. The public protector that is correct.
Now, so, can I just ask you this? You see, assuming this order is appealable and assuming we can interfere with it, let me just raise this. You say it should have been sent to the minister and the board.
Yes.
To consider whether or not to suspend.
That is right.
Well, there was the report of the public protector, which made some very serious findings about the individual. In circumstances where the board had been asked to institute disciplinary proceedings, it doesn't. Not just that, it then decides, in the face of that report, to appoint him permanently. Now, in those circumstances, why shouldn't a court order the suspension? Given that history, given the fact that there was a report that the board decided to ignore, a report that made very serious findings about it.
The important part about that is the report didn't require the exercise of discretion by the minister or the board. Now, the difference with the tender case of Trencon that is given as authority for the...
let's forget about those cases. Let's deal with the facts. We've got... And the facts, up until that point, were pretty damning as far as Mr. Motswanenga is concerned. And you would have thought that on the strength of that, if the board had brought an independent and impartial mind to bear, insofar as the report is concerned, appreciating that it was a public broadcaster acting in the public interest, it would have taken the necessary disciplinary measures. Certainly, one would not have expected them in the face of the report to have permanently appointed the man. Now, having permanently appointed the man, why, in those circumstances, would the High Court, why would the High Court be wrong in entertaining genuine suspicion that the SABC board would do the right thing when the thing is referred back to them? What do you suggest they would have done had the matter been sent back to them?
There is no suggestion in these papers, and no suggestion can be made that the SABC and the minister would not act in line with the court judgment. So if the court were to make the finding based on the papers at that time, that on the face of what is contained in the public protector report, the reasonable thing, or the court would have expected the minister and the board to consider a holding suspension and refer that back to the board. There is no reason why the board, in light of the judgment, would not make the right decision. And that is the same case here.
Well,
if this court were to say...
It didn't earlier. Isn't that the fundamental difference?
But the new factor in that would be the court judgment, because the court would...
Well, why did it need a court judgment to tell them?
Well, that's
the public broadcaster acting in the public interest. There's a complete abdication of its public interest role when it decides to ignore the public protector's report and then to appoint somebody against whom serious allegations are leveled.
With respect, even in the Mbuli judgment, the kind of allegations that the court was dealing with and the decisions to discontinue those proceedings which were to address the allegations were very serious. But the court nevertheless stayed within the proper realm of its powers in terms of separation of powers and said, there's no reason, the public authorities who are given the power to exercise the discretion must be given an opportunity to exercise that discretion.
I'm a bit conflicted by the debate. If you could turn to page 813 of the judgment, it's volume 5. It's really para 98 where the judge in the court below deals with why Mr. Motsueneng said he should not be suspended. And then he says the suspension would be given an opportunity to respond. Suspension carries negative, so he says everything that Mr. Motsueneng said why it shouldn't be. And then he goes on to say why they don't bear scrutiny. He says, in my opinion, those reasons do not bear scrutiny. The separation of power argument fails for two reasons. First, I found that the decision to reject the public protector's findings was irrational. So we go to the rationality test. It is difficult to conceive how the rule of can be said to be undermined by the rationality inquiry. It's nothing to do, either the decision is rational or it's not. Then it says the rule of separation of powers cannot be used to avoid the obligations of a court to provide appropriate relief that is just and equitable to a litigant. Then he deals with the rules of natural justice. As regards the rules of natural justice, the particular circumstances of this case warrant the suspension of Motsueneng pending the disciplinary inquiry. It is unlikely that the respondent would even consider suspending him. The papers show that the board voted to remove him from the position of acting COO, but that decision was reversed by a new board. When the public protector required disciplinary action to be taken, the minister appointed him permanently to the post of COO. Finally, it is simply wrong that Mr. Motsueneng's suspension would create a public perception that he is already guilty of misconduct. Any prejudice that he might suffer will be significantly contained in that he will suffer no loss if there is remuneration and the suspension is for a limited period. Now, I think the argument, the difficulty, and the reason why I'm conflicted, and I'm accepting for the moment that there is forcing what my brother Ponnen put to you about why in these circumstances the suspension should not be ordered. The difficulty I have is, well, in that case, if they behave in this fashion, why should a disciplinary inquiry be done? Because maybe that's a dead letter. I just have difficulty with drawing the curtain, because I could understand the DA skepticism and the other party's skepticism about whether it will go anywhere. But I mean, either the process will have integrity, that's why you order it, or it won't, and that may be subject to challenge. But I'm conflicted by it.
May I say, we submit in paragraph 100 where the court says it's unlikely that respondents would even consider suspending him, that at that point, once the judgment, after a judgment is granted, making the findings that the High Court made, it was a misdirection to conclude that even with the judgment of the High Court, the respondents would never consider suspending Mr. Motsueneng. And in the same breath, accept that they will institute disciplinary proceedings in accordance with the judgment of the court. What the court should have done is to accept that they might have omitted to apply their minds to the possibility of a suspension, but once the court made the findings it made, as this court did in Ndluli, that the respondents, there was no basis to assume that the respondents would not follow the judgment of the court and properly consider the possibility of a suspension, and that if that is not properly done, and there's an avenue for a challenge, the court will control it through judicial review. So our submission is the court here readily assumed the power given to the...
Perhaps I'm less charitable than you are. But they had the chance to do the right thing, you see. It's not like they didn't. They had the opportunity to do the right thing. They didn't. A court then, there's an order of the High Court saying, you've now got to institute these disciplinary proceedings that you should have a while ago. There again, they had the opportunity to abide the order of the High Court. Lo and behold, they're on appeal before us, saying, actually, you didn't give us a chance to do the right thing.
Well, where we are now, they abide the decision to institute disciplinary proceedings. The submission I make is, in light of the judgment of the High Court, and what this court will say after hearing all argument, when the matter goes back to the SABC to institute disciplinary proceedings, there's no reason to assume that the minister and the board will not properly exercise the power to consider suspension as a necessity. But to take that discretion away from them on the basis that previously, where the public protector didn't require them to suspend, that previously they simply failed on their own initiative to consider suspension, we submit is a ready usurpation of the power.
Do you have a difficulty with the ancillary orders relating to time?
No, not from the SABC with respect to time. All we submit is if this court will uphold the order to institute disciplinary proceedings, and we ask that the order to suspend, immediate suspension, be set aside, and that issue be referred back to the minister and the SABC to consider suspension.
Can you just remind me again? I think you mentioned the Rule 4911.
Yes.
Application.
The execution, yes.
And I think the order was made that be so. What happened? Was there
what
appeal
happened
against that?
Yes, there was as Justice Mpati would know, there is an automatic right of appeal under the Superior Courts Act, and so there was an appeal. The appeal hearing was convened in June. All the parties were ready to argue the appeal, and the council was summoned to chambers to meet the judges, and my learned friends will correct me where I get it wrong.
That's when it was expedited.
Yes. Then it was put to it was suggested or inquired of the parties whether it would not be appropriate to expedite this appeal as opposed to running that appeal and then running this appeal and running the Part B review. And after discussions, it was agreed to approach this court to expedite this appeal, and all of this with the good intentions, as it was commented earlier. Sometimes something that looks more expeditious and clever doesn't turn out to be so.
That's exactly the point.
Yes. So that's why we are here.
You see, I can understand to some extent the third appellant saying, well, I shouldn't be suspended. But I can't understand why the board and the minister would resist the suspension.
The minister and the board, if I may put it, and this is not a concession, I'm just clarifying.
Yes.
The minister and the board are concerned that in circumstances such as this, where the suspension is a possible route to go, it is for the board to consider not only the interests of the employee, but to consider the interests of the SABC and decide whether in the circumstances where it's all agreed, the allegations on which disciplinary inquiry should be conducted have been investigated, they're catalogued in the Public Protector report, there is no direct evidence that Mr. Mtswening is going to interfere with witnesses, that all of those factors are in the first place to be taken into account by the appointing authority and the SABC, and a decision made, and they understand that decision will be open to challenge and controlled by the courts. But why they're here before the court is they make the respectful submission that the High Court did not approach the matter on suspension on the right principle, and that is why they asked the court to interfere.
But I think the argument, and tell me if I'm wrong, in the heads of argument was that they were never, or rather Mr. Mtswening was never given an opportunity to put his case with regard to the suspension part.
That will be before the appointing authorities and before the SABC. In other words, that the High Court proceedings are not a substitute for that which is promised to all employees.
No, I'm just raising that because the response to that has been that, well, this has played itself out in the High Court, and he had an opportunity before the High Court to put his case. Why do you need another opportunity?
The High Court proceedings, our principal submission is
maybe we should be asking this to Mr. Aronson.
Yes. But the High Court proceedings, in our respectful submission, is not a proper constitutional replacement for the first exercise of discretion by the employer because of the various interests that must be taken into account. That's the first. But the second thing is then an employee to whom the SABC promised
you will be treated like all other employees in a particular way in terms of the personnel regulations. And the LRA promises that if you are unfairly suspended, you have a remedy under the LRA. All of that is taken away. But we submit in circumstances where there was no direct evidence that Mr. Motswaneng is going to interfere with witnesses in the disciplinary inquiry. Because as regards the investigation, that is complete. Because the disciplinary inquiry is to take place on the strength of the findings of the public protector.
Does the board anywhere say that we have these considerations that we have to take into account? Just so as to assist us, to have some insight as to what they have to take into account, other than saying, this is our process,
Yes.
and then it must be taken out of court.
Unfortunately, we don't have the record in the 4911, the execution application. In the SABC does put up considerations about Mr. Motswaneng being immediately suspended, but in the High Court it wasn't put up. And as I say, the High Court proceedings were, rightly or wrongly, focused more on the disciplinary action and whether the failure to implement was a rational action or not rational action. And there wasn't sufficient focus in putting all the circumstances before the judge. But that, in fact, supports the contention we submit that then the court was not in an appropriate position to make the proper assessment with regard to suspension, because you've got to have all the factors before
Could I just ask you a last question? It's page 779 from my part. It's
page 779.
Page 23, yeah. That's the judgment.
That will be paragraph?
That will be in volume 5.
Yes.
All right. It says in a proper reading of the relief in part A of the notice of motion, more specifically the disciplinary proceedings be instituted against the claim is one for final mandatory interdict. That's correct. It's right that whether an interdict is final or interim depends upon its effect upon the issue, not upon its form. So you really seem to have categorized what was sought in paragraph 1 as final relief. Well, in effect, as my brother Ponen put to you, the relief in relation to the suspension is one pending the outcome of the disciplinary inquiry. And so he didn't separate that. He just seemed to have rolled it all into one.
He rolled it all into one and gave a final relief. And that is why we can come before you and complain. In our respectful submission is that if the court will uphold the order as the parties have said they abide to institute disciplinary proceedings and set aside the suspension order and refer that back to the minister and the board. Those are our submissions.
Yes, thank you.
It's been a long day, Justice. But
very long day.
We, like the other appellants, accept the practical solution suggested by the court. And the only issue which remains for us to reply on the facts, it's a question of suspension. I understand that the DA is not inclined to accept that practical approach. And we understand why it is not so inclined. I ask the court to consider what it says about Mr. Motswaneng. That gives context to its position. And that is volume 1, page 17, 17, paragraph 21, where it deals with the history of maladministration within the SABC. I pick up the reference in the middle of paragraph 21. It demonstrates that the decision to appoint Mr. Motswaneng is symptomatic of a culture of poor corporate governance, abuse, and impunity in the SABC. It shows the toxic role that Mr. Motsoeneng has played in promoting that culture beyond even the ruinous findings of the public protector. And it demonstrates the irreparable harm that allowing Motsoeneng to remain in his position will cause. In other words, the problem of the DA is not whether or not disciplinary inquiry must be instituted against Motsoeneng. Its problem is that Mr. Motsoeneng is at the SABC and should not be there at all. And if that's the problem of the DA, then whatever practical outcome the court may suggest to this litigation won't matter. We submit that the practical outcome is desirable because it is supported by all concerned except the DA. It remains for me to address the question of the order of suspension. We would submit that the court should not uphold it. Having regard to the reasoning that underpins that order, I ask the court to consider the reasoning that was followed by the court below in granting that order. I will focus on 2 paragraphs to illustrate why the reasoning is problematic. The first is paragraph 99 on page 813 of volume 4. There the court said the following: in my opinion, these reasons do not bear scrutiny. The separation of powers argument fails on 2 reasons. First, I have found that the decision of the board and the minister to reject the public protector's finding and remedial action was irrational. It is a reasoning that is based on an assumption of matters of fact that will arise in Part B of the proceedings. And we therefore submit that that approach is fairly wrong on the facts, because there is no evidence at all that the minister and the SABC rejected the findings and remedial actions of the public protector. In our main argument, we drew the attention of the court to the version of the minister about how she intended to address the remedial action of the public protector. The second point that I'd like to deal with arises from paragraph 101 of the judgment of the court below on page 814. Finally, it is simply wrong that Mr. Motsoeneng's suspension would create public perception that he already is guilty of misconduct. Any prejudice that he might suffer will be significantly contained in that he will suffer no loss of remuneration and the suspension for a limited period. We would submit that the court failed to telescope the consequences of that suspension. Because if you suspend Mr. Motsoeneng now, you will have to inevitably provide for his replacement, because the SABC cannot, we would submit, run a mammoth, complex organization of that kind without a technocrat occupying the office of the COO. Inevitably.
Is there a GCEO now?
Apparently there's a GCEO now, but that GCEO is an executive who does not deal with functions and duties relating to the COO. The chief operating officer is a technocrat who runs the technical aspects of an organization.
It's the nuts and bolts, man.
It's the nuts and bolts. And Mr. Motsoeneng has been there for quite some time, has run that office in both acting and permanent capacity. If you remove him, telescope the consequences of the removal by way of suspension, you have to provide in the interim for someone.
What will you do during the disciplinary inquiry?
Well, either you would call him, as my learned friend Mr. Manager has suggested. You hear him, and once you've heard him, you will decide and adopt a balancing exercise. The difficulty is there has not been a balancing exercise in this case to see how not only his interests, but also the interest of the SAB themselves should balance in the end. And secondly, whether in the course of balancing exercise that you undertake, there will be someone fit enough to replace him during the process of disciplinary inquiry if he were to be suspended in due course. And so we will submit that this reasoning is not enough. And ultimately, it carries with it consequences of financial nature for the SABC. One knows that if you suspend Mr. Motsoeneng immediately, you appoint an acting COO, you will have to doubly pay for the occupation of that office by someone who's not on duty because of the suspension and someone who's acting in the meantime. And these are the type of financial consequences which
Well, you did that for quite a while.
I missed the point.
I say it already did that for quite a while.
Indeed.
Yes.
Indeed. And there's no suggestion by the DA that if you were to allow Mr. Motsoeneng to continue what he's been doing for quite some time, that would result in serious consequences for the SABC. They seek to persuade the court that Trancon, which is now lifted for the first time in the course of oral argument, indicates what is just and equitable. We have looked at that case in a different context, and our recollection of it is that Trancon is against them because Trancon was dealing with the grant of a substitution remedy in circumstances which were exceptional. And the Constitutional Court concluded that circumstances were exceptional, and therefore it could take over that power from the IDC to appoint a successful bidder. Those would be our submissions on the fact. There is just one point that I'd like to address relating to the arguments on behalf of the public protector about how the court should approach it. I'm just going to make 2 points, understanding that these are matters for argument. The first issue relates to the submission that the powers of the public protector under Section 1821 entitles her to make appropriate remedy or to take appropriate action. We accept that that is the language of Section 1821, but we would submit that that part of Section 1821, which talks about appropriate remedial action, must be read together with the opening language of Section 1821, which says that those powers, as are regulated by national legislation, will give rise to remedial action which is appropriate. And we would submit that syntactically, you cannot separate that part of 1821 which deals with appropriate remedial action away from the opening language of it, which says that those are the powers as regulated by national legislation. We've drawn attention in our main argument to what we consider in the context of the debate before the court. What is national legislation? We submit that that national legislation is the Public Protectors Act.
I don't know if that's correct, Mr. I don't want to prolong the argument because we've gone through it again.
Yes.
But if you look at Section 182.1, it is not exclusive as it was. There's no cutoff point. It says the public protector has the power as regulated by national legislation.
Yes.
2, do X, Y, and Z. So whatever else it's given, it's not a limitation. It's if anything, it's the detail. It's the flesh that's put on the bone. But the bone is the bone. And the bone is quite substantial.
And if the flesh falls short, does that not mean you go back to the bone?
No, with respect, not. We would submit, on this language, unless we read it this way, and we may be wrong, I accept, but let me tell the court how we read it. If you look at the syntax of that section, it introduces right in the beginning, in the preamble of this section, it introduces right in the beginning, regulation by national legislation. And thereafter, it lists what the public protector can do as regulated by national legislation. So we would submit that when you look at the powers that are specified in A to C, you have to look at it in the syntax which says that those powers derive force as regulated by national legislation.
Suppose national legislation leaves out one of them listed there, then what?
This court and the Constitutional Court has told us that where that is the case, then national legislation will be unconstitutional. that will be unconstitutional. And therefore you have to attack that national legislation.
I'm not sure that that's what the...
And ignore what is in the Constitution?
Pardon?
And ignore what is in the Constitution?
No, in the meantime you'll apply the Constitution, but that national legislation would be unconstitutional.
Well,
in the meantime you'll apply the Constitution.
And if no one has attacked the national legislation?
Well, my sense is that if no one has attacked national legislation, that legislation will apply.
Yes. And if it doesn't deal with another power that is listed in the Constitution?
Well, I mean...
will she not have the power? Will she not have that power?
That's the point. It
won't be absorbed into thin air. It won't just dissipate.
I made my submissions. I don't want to replay the cassette. Let me move on. The next point that I'd like to deal with relates to the question of effectiveness of the powers of the public protector. We now understand that the submissions on behalf of the public protector is that unless you read binding effect of her reports as a proxy for effectiveness, legal effect, then we will rest our submission on the basis that legal effect does not mean that effectiveness will always be achieved by a binding.
Well, I understood Mr. Marcus and Steinberg to say they accept that it's not absolute.
Indeed.
It may be subject to challenge, but it stands while it stands.
It stands, but it may, effectiveness can be gained by means other than a binding finding or recommendation.
That happened in the court.
I'm sorry, I'm not sure I quite understand that. I mean, perhaps it's late in the day, perhaps it's my simple mind, but do you just want to elaborate on that submission?
What we would ask the court to consider in that regard are a number of indications in the Public Protectors Act which shows how the Public Protector's findings and reports can be given effect to in a manner that is effective, other than the reports being binding. One of them is...
Let me ask you this. Do you accept, and I understood all of you to accept earlier, that absent a proper challenge, her findings cannot be ignored?
Oh yes. I mean, that's where we are.
Yes. Well, then the rest becomes something of a semantic debate, does it?
Indeed. Well, those will be our submissions in reply. So that I should not shortchange my client, Marlena Jr. asks me to refer a court to a judgment which no one has referred to in the heads. The citation is on shelf, trading 9NINE, Pty Limited versus De Klerk, NO and others, 1997, Volume 3, South African Law Reports, page 103, the judgment of the then Witwatersrand Local Division. The import of the judgment is, even in circumstances where you suspect that the decision maker may well be biased against you, you must nevertheless go there and appear before it. And if ultimately its decision cannot be rationally explained other than biasness, then you can attack it.
Who was the judgment by?
It was Straha J, as it then was.
Was that a matter of an appearance before an arbitrator or something?
No, it was a matter where the then South African Telecommunication Regulatory Authority awarded a telecommunication or broadcasting license to one of the bidders. And that award was challenged successfully on review. But the successful review applicant sought to persuade the court to take over the power of SATRA and give it the license because it feared that the SATRA was going to be biased against it.
That's understandable. Yes, thank you.
Just in relation to the nature and effect of the public protection's powers, may I just ask the court to look at our heads, paragraphs 23 to 38.
To 38.
23 to 38.
Yes.
On page 12 to 17. Now, just in relation to the suspension again, it certainly would be unprecedented for a court to order the suspension in circumstances where this court, for example, as it seems to be inclined to do, that the report of the public protector and her remedial action recommendations, proposals, must be given effect to, and if you don't, then you must go to court to have them set aside. Now, the remedial action that had been proposed by the public protector, it seems to me, in this case, respects the separation of powers. Because in the first place, she says to the minister, there is no COO. This whole report has revealed a number of problems within the public broadcaster. That's why she asked for the roles to be defined and that kind of thing. And she said, but she doesn't dictate it to the minister. She says to the minister, fill that post. Then she says, my investigation also reveals that there are problems with Mr. Motswaneng. And it's highlighted in the report. But again, she does not say, because of those problems, you must dismiss him or you must suspend him. She says quite rightly, take disciplinary action against him because these problems that have been highlighted are of serious concern to me. That's what she does. Now, if that's accepted, then ask oneself the question, and I think the answer then reveals itself. What if the SABC and the minister complied with the public protector's remedial action? Would the DA, independently of that, still have had the right or the legal standing to go to court to say, we insist, on top of that, that Mr. Motswaneng must be suspended?
But that's assuming that they gave in.
Yes. So that cannot happen. Now, that is the question before this court with respect. The Trenkong case is clearly distinguishable because that was a full-on review, and the court found, the Constitutional Court at the end of the day said, we in a perfect position to make a just and equitable order. That brings one to the problem with Judge Skipper's judgment. He ventured into Part B, found illegality and unconstitutionality with the appointment, and came back and said, for those reasons, I must find a just and equitable remedy, and that is to suspend Mr. Motswaneng. In circumstances where Mr. Motswaneng had been acting, by the time he gave his judgment, for almost a year. For almost a year he's acted. There's no complaints.
I somehow believe that I've heard that argument from you. Is it now in response to what Mr. Katz argued?
Well, I'm concerned, speaking as counsel for Mr. Motswaneng, that I've also heard during Mr. Katz's presentation, Mr. Justice Ponen raised repeatedly the issue of why can't the court suspend him? And I'm trying to address that.
So you say now you must also repeat what you argued.
No, I'm not saying that I'm entitled to address it in reply.
No, sure, you are.
And we've heard you.
And you've heard me, and if you're satisfied with the answers that I gave in my main address, then I'm quite happy to sit down. I think we've assisted in arriving on what we thought is a practical solution to this problem.
I don't think you expect us to say we accept what you said.
No, Mr. Arnold, we're in no way suggesting that you haven't been of assistance.
Yes.
No one has suggested. In fact, you've been very helpful, as all. But so that's not the suggestion. But repeating it's not going to improve the argument.
Yeah.
No, it's not a matter of repeating. It's a matter of re-emphasizing some basic principles. In fact, one of the issues raised by His Lordship in party presiding is, but did Mr. Motsoneng not get a hearing in the High Court? That is exactly the problem.
Well,
his affidavit was before the court. He controverted the many findings of the public protector. Because this application of the DA was based on hearsay and speculation and newspaper reports, they were unable to deal with it. There is no basis for Judge Schippers to have rejected the facts presented by Mr. Motsoneng and by the SABC in relation to other complaints of...
Mr. Arons, I don't want to cut you short, but I understood you made that argument when you said they didn't apply Plaskon Evans, they didn't apply the proper test. You said that in your argument.
Yeah, and I know it's Friday and it's late. And I'm batting last in the fading light.
No, to be fair to you, I think when I asked, I think it was Mr. Maneki, a question, I said, maybe that's best asked of you. You're probably dealing with that now. You have been dealing with that, isn't it?
Thank you. So we would submit that the appeal in respect of the suspension be upheld with costs, and that and that an order be made that the allegations contained in the public protector's report be referred to a disciplinary inquiry.
Of course, in respect of all counsel, costs would be costs of two counsel. Am I correct?
Yes, my lord.
Yes.
Thank you.
Yeah, shall I close the days? Yes, thank you. Judgment will be reserved in the matter. The court will adjourn.
And then reply to okay.
One question fail.
Okay.
Mr. Majavu, are you happy with the deliberations thus far?
Extremely happy and very satisfied that the issues that we've been complaining about will be properly ventilated. Judgment has been reserved and we remain confident.
Mr. Mtsening, and the suspension?
No, he's still in charge. The DA wanted suspension Goku. They didn't get it, and I guess until the 5 judges decide otherwise, he remains firmly entrenched in his position.
Ntate, ibe taba ya suspension go se fetse ka mkho e tsamaileng ka teng?
Hantle haholo dingangisano di tsamaile ka tsela e nepahetseng mme re hlompha lekgotla le tsamaiso ya toka. Ha o utlwa tabeng ya suspension Ntate Motshweneng, DA ne tle e batla gore ba mo suspende hang mme ho ya ka dingangisano taba eo ha ya etsahala mme ho fihlela lekgotla le nka qeto Ntate Motshweneng o tla ulang tsa sekotso metse sa maratswana ho fihlela lekgotla le nka qeto ka ona motsotso Ntate Motshweneng o sane o seng o tla ba le ofising ho fihlela judgment e etswa.
Will he be at work tomorrow?
He's going back to work tonight. He says he's got things to do tonight, and that's exactly what he's going to do.
Yes. No, you do.
No. My way. My way, Timcha. Not full time. Not fully. Ke a tseba o tswe. Ha mpone go tswa maele mona bo. Na ntho e robile ke sebetsa le ya no channel. E feng? Marantsi. Oh. Na ke khotlotse. Ana ke public protector ke tile ka DA ntho. Tshwara maja. Comment on te tire ça? Yeah. Je vais le gars pour tout ça. Net procedure. Alors mais c'est une chose. Mais on peut dire le gars pour ça. Quoi? That's what I want. Yeah. Out of film. Nie me la chose ka public protector. Yeah. I went to this man many years. Yeah. No. No. Emelang kamu lah segasinya sudah besar na butat. Segasinya sudah besar basya na ba mahike. Iri ukupo tebza kama. Okay. Ufana ka buka body. Arna microphone. Microphone one. Iri tebza dual tebza kama. Dual tebo.
Ay, Liana public protector. Was okay, but where is she? Okay. Sebetsa dimika. What's working? So kwa.
Kisa tebo ba fewa. Tebo ba.
Ubane. Le Ukraine. Oh, okay. Okay. But you don't have to. It's like it's a cassette. I can read that cassette. And then rush it. How cool? Rush it to office. Adrian and get some rights. I'd get a package. No, but they come, Babaka Krosakai. Mole. Why? You can't do. How about get cloudy love you? Bona, Babata that thing live now. Zamayang. Kitando, you must put that address live. Because it's a hale to have that table there. I told them.
Tatolo lo babitsi. O timme khatlas. Yeah. Yeah? That mic is on.
1, 2, 1, 2.